One of the most common questions individuals ask is, how am I protected as a whistleblower? Well, there's really two streams of protection. There's proactive protection, which sometimes involves anonymity, and there's reactive protections about what happens if an individual is retaliated against. There's also a third stream, which you don't want to be swimming in, which is no protection at all. And we'll get to that last. The proactive protections in certain statutes enable the whistleblower, particularly with the use of an attorney, to stay anonymous technically from start to finish, although that's not guaranteed. Those statutes include the anti-money laundering statutes, SEC whistleblower statutes, CFTC, and IRS. Why I say it's not guaranteed is because if the case goes on a criminal trajectory, technically it may be discoverable down the line, and you should go over that with your attorney about the chance of ultimately being discovered. But if you're cloaked in that anonymity, you have wonderful protection, potentially from start to finish, and also if your attorney wrote it up the right way, to also additionally help conceal your identity, but let the government know that you know enough for the case to succeed. A quasi-prophylactic measure through proactivity is through the False Claims Act. Because even though you're not technically supposed to be anonymous under the False Claims Act, it's filed confidentially under seal so the defendant doesn't know about it, oftentimes for many, many years. And certain times people file it trying to add another layer of protection. They file it under a John Doe, they file it under a dummy corporation, through a straw relator. All techniques have its pros and cons about shielding identity. However, False Claims Act is litigation within court. So at a certain point, after the government makes a decision whether to intervene or not, if the litigation progresses, there's a pretty good chance that the individual's identity will be addressed or disclosed. The second stream of protection is the reactive protection. And what I mean by reactive is if somebody's actually retaliated against as a result of them blowing the whistle, the statute calls for certain streams of damages like double damages and attorney fees. Now, all the statutes that have proactive components also have the reactive components to some extent, but you really need to understand how and when to invoke them. And before you file a whistleblower case, really plan your parachute. Understand what your options are, particularly if it's blowing the whistle on a work environment. And the third thing, unfortunately, involves no protections at all. And as you've heard me articulate different statutes so far, unless your case falls squarely into a statute, you do not have protection. People have difficulty understanding that for some reason, and I understand because they hear, oh, I'm a whistleblower, shouldn't I be protected? Well, it depends upon what are you blowing the whistle on. If you're blowing the whistle on Medicare fraud and you work for a healthcare provider, yeah, potentially you have great protections under the False Claims Act. But if you're blowing the whistle on your boss who parked in the wrong parking spot, or somebody ate your lunch out of the fridge, you may feel like you're blowing the whistle on somebody, but unless there's an identifiable statute, you do not have protection and your employer can potentially fire you. That's why we always advocate speaking with a quality whistleblower law firm, not just our firm, Brown LLC, who offers free consultations at 877-561-0000. But please do some research, try to find out some of the best whistleblower law firms and call them to see if you click with them and they can guide you for your potential case.